Well, good morning again and welcome back. I am Catherine Shoemaker. I'm an assistant professor of classics and letters, and I'm pleased that you could join us here today for the University of Oklahoma's teach-in focusing on the strength and fragility of constitutions. Thank you to Eric Weitz, who's out there somewhere, for that wonderful talk. And our second speaker today is Laura Edwards, the author of A Legal History of the Civil War and Reconstruction, A Nation of Rights. She is also the author of The People and Their Peace, Legal Culture and the Transformation of Inequality in the Post-Revolutionary South, Scarlet Doesn't Live Here Anymore, Southern Women in the Civil War Era, and Gendered Strife and Confusion, the Political Culture of Reconstruction. Professor Edwards is the Peabody Family Professor of History at Duke University and an affiliated scholar at the American Bar Foundation. She works on the 19th century United States with a focus on law, gender, and race. Please join me in welcoming Professor Edwards.
Hello, and thank you, Catherine, and thank you, President Boren and Kevin Butterfield. This is wonderful to be here. I'm loving Oklahoma, And today I'm going to switch from Germany and downfall of constitutions and talk about a constitutional transformation within the United States, one that is fueled by ordinary people like all of us, which is why I'm going to start out with Maria Mitchell. And let me make sure I get this going. Ooh. I never know the PowerPoint's actually going to work. Okay, so far so good. Okay, 1870. Edgecombe County, South Carolina, and Maria Mitchell. She's an African-American woman, and she did something that she could not have done just a few years earlier when she was enslaved. And what she was doing was, as she said, talked for her rights. Now, she's talking for her rights because she's having a problem with a man named B.D. Armstrong, who is a white landowner and also likely her employer. And according to the testimony in the trial that followed, Maria Mitchell expressed her anger in a form common to the 19th century South, a highly stylized verbal barrage that's intended to attract attention to the incident and to shame her intended target. Or, as her son put it in his testimony, his mama was talking loud. So Armstrong then demanded that she stop. Mitchell responded that she was talking for her rights, and she would as much as she pleased and as loud as she pleased. And so Armstrong, the employer, issued a threat. If she did not hush, he would make her hush. When Mitchell continued to denounce him loudly, according to the testimony, he struck her in the face and broke out a piece of her tooth, or so she testified later, when she turned her words into action and filed charges against him. So I stumbled across Maria Mitchell's case years ago. Actually, it was decades ago. I was working on my dissertation. And I flagged it at first because I thought it provided a particularly compelling example of something that I already knew, how the defeat of the Confederacy and the constitutional changes of the Reconstruction era opened up the legal system to African Americans. And it all seemed so clear at that point. Maria Mitchell had rights in 1870 that she did not have before when she was enslaved, and she was claiming them, and she said she was claiming them in very no uncertain terms. Now, she had those rights because of passage of the Reconstruction amendments, particularly the 14th Amendment, which provided federal protection of civil rights by, among other things, prohibiting states from discriminating on the basis of race. Maria Mitchell's words that she was talking for her rights and would as much as she pleased and as loud as she pleased underscored the importance of those changes in a way that was hard to miss. So I thought I had it all figured out, although I've discovered rarely do I have everything all figured out. And in this case, I really didn't have it all figured out. My initial interpretation here obscured a much more interesting story, a story of constitutional change that's located in places that most of us would be hard-pressed to find on a map, and in the context of legal matters that most of us would consider unremarkable, let alone constitutional. The key to this other story actually lay right in front of me, although I didn't realize it at the time, and I mean that literally in the documentation of cases in local courts, cases like the one of Maria Mitchell. So these are not the published sources, the statutes, the appellate cases, the legal treatises that most people associate with law and with legal history. These are loose, handwritten documents. Some were produced by circuit courts, which met on a regular basis in court towns and which held jury trials. The more interesting documents, though, like this one, the one of Maria Mitchell's case, were actually produced by magistrates, many of whom had no legal training whatsoever. And magistrates in the early 19th century set up court where they were, taking time out of their day to hear complaints, to issue warrants, to adjudicate minor cases, and to send more major issues up through the legal system. And the people involved in these cases took an active part in all of these cases. They collected evidence themselves, they provided information, and they observed the proceedings. And you actually see this context in the documents. The handwriting is by the officials themselves, pen in hand, often struggling to keep up with the oral testimony and to capture the words in writing. The names are of all those people there, men and women, rich and poor, white and black, free and enslaved, old and young, hashing out life's problems. And you can even hear the people talking if you read these cases out loud. You hear bits of French, a little German in the accent, some Irish, definitely some Scottish, and certainly the Creole cadences that mark the speech of so many people of African descent. My mama was talking loud. And if you keep looking, you can see the laws that worked in people's lives. This part of the legal system, focused primarily at the local level, was charged with maintaining the public order, or in the terminology of the time, the peace, keeping the peace, a body of issues that included all but the most serious criminal cases, as well as a broad range of issues involving public health and welfare. The expectation was that officials would adjudicate conflicts in the community, doing what was right, although obviously not everyone agreed on what was right, and not everyone's opinion carried equal weight, given the rigid inequalities of the 19th century. This legal framework, moreover, was not just Southern. It wasn't just people like Maria Mitchell and Edgecombe County, North Carolina. It characterized the operation of law in local courts throughout the United States, and it was the legal framework that was most familiar to most Americans in the early 19th century. Once local cases were concluded, the documents then were folded in thirds, they're tied with a ribbon, filed away, and they have been largely forgotten. And so, too, was the legal context that produced these documents. So this is the outside of Maria Mitchell's case, and you can see the folds there. I was pointing to the computer, but you could see the folds back there, and that's where it was folded in thirds and ribbon tied around it. So it is hard to imagine that this legal framework, maintaining public order in local communities, doing what people there thought was right, has anything to do with the 14th Amendment and the rights it protected. But it did, as I will explain to you today. And so in this explanation, we're going to take a journey to places that are frankly strange in the context of a talk about constitutional law. Places like Edgecombe County, North Carolina, and the venues of local magistrates. But I promise you will get back to familiar constitutional terrain, Washington, D.C., the federal government, the U.S. Supreme Court. But hopefully the journey will render those places less familiar than they are to you now. So to tell the story, I will first talk about the legal system in the early 19th century and the two different frameworks that were operative then. One focused on individual rights at the state and federal levels, and the other that was focused on maintaining the public order and doing what was right at the local level. So we have two rights, a right and what was right. And they both mattered in the 19th century. Then I'll explore what happened after passage of the 14th Amendment, which brought those two legal frameworks together and encouraged Americans to see federal authority as the protector of both rights and what was right. The result was a rights revolution, one that predates the rights revolution of the 20th century, the one that we associate with the civil rights movement. And it was initiated by ordinary Americans who transformed not just the meaning of rights, but also the reach of federal authority, stretching both to cover a much wider array of issues than had been the case before the passage of the 14th Amendment. And this was not necessarily the intention of the lawmakers who framed that amendment, but that was the result. And the implications have been profound and enduring, supporting expansive expectations of what rights and federal authority can accomplish even to this day. So when I first read Maria Mitchell's case, I took her assertion of rights at face value. It seemed obvious. She was claiming rights that other American citizens had, but that had been denied to her by state law until the federal government interceded with the 14th Amendment. But when I returned to the case after writing a book on legal culture in the early 19th century, her claim struck me as really odd, or at least my interpretation of her claim struck me as odd. It was research for that book that made me come to terms with what local records said about the structure of law in the first half of the 19th century. And as I learned, people rarely, if ever, evoke their rights in the context of cases at the local level, in criminal cases like Maria Mitchell's. And that was because local courts did not use the framework of rights to adjudicate those cases, or for that matter, any of the matters involving the public order, which included criminal matters and all this wide variety of issues relating to the public order. And at one point I had thousands of cases, I went through and looked for rights. And there were three ways that rights were used in the context of these cases. Right as opposed to left, right as opposed to wrong, and then right as an intensifier. And I do Southern history, so this will make sense, but she was right smart, for instance. So those were how rights are used. Most Americans, including those outside the South, actually were very familiar with the operation of law in this area of the legal system because it depended on them. They played central roles in all the proceedings. And by most Americans, I really do mean most Americans. Even enslaved people who were marginalized and had less say in this system still watched it operate on a regular basis. So given that context, Maria Mitchell in 1870 had to have known that rights, individual rights, had little power in her case. So what did she mean when she said she was talking for her rights? And to answer that question, we need to consider context, law and the legal system in the early 19th century. So today, when we think of law, we tend to think of decisions of appellate courts, statutes of legislatures at the state and the federal level. We think of white column courthouses and capitals where law is formulated by lawmakers and everybody else follows them. But that was not the case in the 19th century, especially the first half of the 19th century. Legal authority, the legal authority of the federal government, and this is the U.S. Capitol as a metaphor for legal authority at the federal level, was not what it would be later. The federal government was actually a distant entity for most people who generally encountered it in one of only a few ways: military service and military pensions, very popular, campaigns for aspirants to federal office, and actually more commonly but more prosaically, the post office. People were more likely to encounter the legal authority of states, which had jurisdiction over most of the actual daily work of governance. States protected the rights of individuals and maintained the public order, doing what was right. Both of those rights belonged to the states. But states then delegated significant power to counties and to municipalities, particularly in matters involving the maintenance of the public order, making local areas, not states, the jurisdictions with which most people were familiar. These were the local venues that handled cases like Maria Mitchell's. And these locations made law part of the fabric of people's lives. They convened wherever there was sufficient space, in a house, a barn, a mill, or a yard. That was true even for circuit courts in the first decades of the 19th century, where many counties lacked the formal courthouses that would later house circuit courts. So here we have the first courthouse in Spartanburg, South Carolina. And it's like, oh yeah, they have a mill. Aren't they cute and quaint there in South Carolina? And we don't really think of it as a real legal forum, but it was. And this is what law looked like. It was part of people's lives. Now, the distance of most people from state and federal government tracked their distance from the individual rights that we now assume to be so necessary and so powerful. So in the first half of the 19th century, individual rights, or rights for short, referred primarily to those rights that at the time were thought to be conferred by the government, namely civil rights and increasingly political rights. And the reach of those rights was limited. Civil rights dealt primarily with the matters involving the ownership and exchange of property and access to courts to defend those property interests. Before the 14th Amendment, the federal government dealt with the rights of individuals only when those people or legal issues in which they were involved were not within a state's jurisdiction. So in the territories, you would encounter federal power. In relation to Indian nations, you would encounter federal power. In the District of Columbia, which was not a state, you encountered federal power. And in federal cases, but there were very few federal cases. And even the rights enumerated in the U.S. Constitution's Bill of Rights remained out of reach for most Americans because they applied only in cases that involved federal law, not state law. You couldn't go into your basic state or local court and say, I'm demanding my rights. Oops, I'm demanding my rights in the U.S. Constitution. And they would say, ha, and they would throw your little pointer on the floor. So it was rights, those rights, they were not as present as they are today. Now, the federal government did not even attach rights to citizenship, and this is something that I think is really crucial but is forgotten. In fact, there was no clear definition of citizenship at all in federal law in the first half of the 19th century. When asked in 1863 during the Civil War to determine whether African Americans could be citizens of the United States, Attorney General Edward Bates's answer underscored the ambiguity of this whole question. Who is a citizen, he asked. What constitutes a citizen of the United States? These are rhetorical questions that he put into his little brief. He found no definition in either federal legislation or judicial decisions, even for Americans who were free and white. So he said, quote, 80 years of practical enjoyment of citizenship under the Constitution have not sufficed to teach us either the exact meaning of the word or the constituent elements of the things that we prize so highly. Now, to the extent that there was a link between U.S. citizenship and rights at all, it was at the state level, where there is a concept of state citizenship, which did establish claims to rights as defined within states. But citizenship was still a murky concept there because rights were not absolute and could be restricted if deemed necessary for the public order. So states' jurisdictions over Americans' legal status was actually why some states could sanction slavery and others not. It was in the state's power to decide whether or not they were going to restrict people's rights to the point where they were enslaved. And it was not just slave states that restricted Americans' rights. All states limited or negated the rights of African Americans, all women, many propertyless men, and a range of other racial, ethnic, and religious minorities as well. No free women of any race, married or single, could claim the full array of civil rights or political rights, or even natural rights. Many men found themselves in a similar position. Free blacks, in particular, had very limited rights, even if they lived in free states. So rights are not absolute. They're always contingent on whether states are willing to grant them to you. Bottom line here, authority over rights did not mean that states and the federal government exercised extensive authority over people's lives. Political rhetoric of the time, which equated rights with freedom, with liberty, and even social equality, would suggest otherwise. But as we all know, political rhetoric does not actually describe reality on the ground. And with some exceptions, rights accomplished particular limited ends within the legal system, even for those Americans who could claim them. So given this context here, it seems odd that so many historians look to state and federal law to understand Americans' legal experiences in the first half of the 19th century. In fact, if you assume that the law was defined primarily at the state and federal levels through the framework that looked after the rights of individuals, you have a very partial, very skewed view of the law before the Civil War. You would have a view of law based on the adjudication of rights, and yet the vast majority of Americans could not claim those rights. Which brings us back to local legal venues, which were charged with upholding the public order and doing what was right. These were the legal institutions and conceptions of law that actually were most familiar to most Americans before the Civil War. Maintaining the public order or keeping the peace was actually about maintaining hierarchy. The peace, this concept, well established in Anglo-American law, and expresses the ideal social order, which at the time subordinated everyone in various ways within it. So the peace was inclusive, but only in the sense that you were forced into it. You had to be there whether you liked it or not. Inclusiveness was not some happy little thing here, it's actually subordination. And it's also not about you. It raises the interests of the collective order over anybody's individual interests. In fact, keeping the peace meant keeping everyone from the lowest to highest in their appropriate places, judged by the rigid inequalities of the early 19th century. The peace was actually about coercion. Now, while this localized system actively subordinated people, it still incorporated a wide range of Americans, free women, children, enslaved people, free blacks, into its basic workings because they were part of the social order that the legal process was charged with overseeing. So even as the system maintained their subordination and regulated their behavior, it relied on information they supplied about community disorder. Women, enslaved people, free blacks, they knew all about what was going on in everybody's houses. So take, for example, 2 cases in North Carolina initiated by slaves. One slave complained to a magistrate that a free black man had been playing cards with other slaves on Sunday. Not good. Definitely not good. Another complained that that same free black man assaulted one of those slaves after the card game. And one suspects there could be other complaints here made about the imbibing of spirituous liquors, which often go along with card games on Sunday. Now, technically, these slaves gave information because laws prohibited all slaves from filing a complaint. But the local magistrate then proceeded with the case based on that information, and he did so in the name of the public interest. Now, of course, these slaves had their own reasons for what they did, reasons that were distinct from the magistrate's likely concerns about disorder among slaves and free blacks. Perhaps they're actually trying to get back their winnings from the free black man who stole them. But as such, this case illustrates central element of parts of this legal system. Different people could pursue different ends within it, sometimes contradictory and conflicting, all at the same time. And that was possible because the system depended on the participation of everyone. In most legal matters, as I said, the interested parties collected evidence, gathered witness, represented themselves. There are cases where people are out there measuring footprints and then measuring suspects' feet and seeing if they fit and if their gait is proper and correct. Now, the definition of interest here is broad and varied, which should actually not surprise anybody who grew up in a small town. And it was not unusual then for witnesses with an interest to line up and come forward and tell what they knew. So you get the repetition of detail after detail from person after person. And the magistrates bore this patiently, knowing that the resolution of a legal conflict was also about repairing a rift in the social order. Now, the law in this part of the system was capacious and uncontrolled by professionals. Thus, calls for reform by many trained lawyers in this period who sought to limit the texts cited in court to legal documents actually recognized as law by their states. But local courts actually included a wide array of kinds of legal principles and legal contexts. So actually, they're relying on local custom, how things have been done in a particular community, accepted wisdom, which could include the Bible, fables and fiction, and the wisdom of somebody's grandmother, perhaps, the kind where she puts her hand on her hip, she sticks her finger in your face, equally applicable in these local courts. And in addition to that, they included a wide array of legal texts as well, including statutes and appellate law, but that was not necessarily the overriding legal text there. And the legal framework used in local jurisdictions then allowed for the handling of situations that would not have had legal standing in state or federal courts. So masters, for instance, would file charges against slaves that they could not control, which is kind of unusual when you think about it. Not what you expect. Wives filed charges against husbands for domestic abuse. Children informed on their parents. Even enslaved people tried to mobilize local courts to address their concerns, as the 2 slaves I mentioned previously did. In fact, families regularly brought their feuds to court for resolution with wives, husbands, parents, children, siblings, aunts, uncles, and cousins, all lining up to air their dirty laundry. And magistrates took these cases because disorder was disorder, and when it happened, people expected the court would right wrongs. Now, the system was profoundly situational, even personalized. One person's experience did not transfer to another person of similar status or necessarily predict any other case's outcome. Each jurisdiction thus produced inconsistent rulings aimed at resolving particular matters rather than producing a uniform, comprehensive body of law. And many saw that situation as natural and just. It made no sense to impose arbitrary rules created elsewhere on local people and local contexts instead of paying attention to the particular dynamics and knowledge in local communities. So local people knew, for instance, that John Smith, he always picked a fight when he drank, but he didn't really mean much by it. He's a good guy. But James Black, he's just plain mean, and he needed to be kept in line. Those two people fighting, they would look the same to an outsider, but local people knew it was entirely different. Or, Elias Carr, he's an enslaved man, but he needs to carry a gun to tend to his owner's business. And Elias has a last name, Carter, because his father had a last name. And we don't know why his father had a last name, even though slaves don't have last names, that's just the way it was. So his son has a last name, but we know that. Or, for instance, Susan Green, she keeps geese and she sells them in a business, and she's a married woman. But everybody knows they're her property, so when they go missing, we return them. Somebody steals them, we return them, and we call them her property even though technically she can't own them. But the geese need to go back to the person they belong to. You needed to know all that information to maintain order, to do what was right. And in determining what was right then, local legal venues and the people involved in them played a crucial role in defining law as well as maintaining the public order. The content of what they were doing was central in defining the legal order in their communities. And this brings us back to Reconstruction, to Maria Mitchell, and to her claims for rights. When she filed assault charges against B.D. Armstrong in 1870 after emancipation and after the passage of the 14th Amendment, she was, in fact, using her new rights to access the legal system. But those rights were actually not the ones that she was talking about. Those rights, the ones that were unspecified but very loudly claimed, those were about what was right. And the charges underscored the point. She charged B.D. Armstrong with assault, a disruption of the public order, not actually a violation of Maria Mitchell's rights. People pursued these cases, violations against the public order, because they wanted public condemnation of behavior at odds with their view of what should be done, what was just. And in the first half of the 19th century, people like Maria Mitchell, though, didn't actually have much room or power to define the public order. The rigid hierarchies that were being upheld as part of the just society in the early 19th century placed Maria Mitchell at the bottom of the social ladder. They could make small changes around the edges, but emancipation then changed all that and opened up the prospect that people like Maria Mitchell could use law to redefine the public order. What was right would no longer be the preservation of slavery and racial inequality. And at the same time, the 14th Amendment allowed those claims about what was right to merge with rights and acquire more power. Before the Civil War, claims about what was right, claims of the slaves who upset about gaming on Sunday, that all stayed at the local level. But the Reconstruction amendments, particularly the 14th Amendment, changed that. These amendments did not just affirm the rights of African Americans, the narrow band of rights, they also made it possible for claims about what was right to travel elsewhere in the system, altering the meaning of that narrow band of rights and changing people's relationship to the federal government. What was right became rights. The two things merged in this period. Now, claims about what was right first traveled into federal jurisdictions through the claims of enslaved African Americans during the Civil War. Maria Mitchell's efforts to use the legal system are characteristic of the actions of many formerly enslaved people. Although contemporary observers and later historians have taken such actions for granted, it is remarkable that people who had been enslaved legally would look for redress in the very legal system that had maintained their enslavement. But they did. Now, historians usually attribute such faith in law to the promise of that narrow band of rights. But formerly enslaved African Americans were also acting on other deeply rooted expectations about the law, that it should maintain a just public order, that it should do what was right. And the promise of the moment then gave them hope that they could access the legal system and legal authority and elaborate their vision of what was right, of what constituted a just society. Now, those expectations explain why enslaved African Americans began bringing their complaints to legal venues during the Civil War, when their claims to freedom, let alone rights, were still tenuous. So once behind federal lines, African Americans sought out military officials and military courts to adjudicate their conflicts. And they continued to do so after Confederate surrender, but before passage of the 14th Amendment, which gave them formally rights. African Americans came to these venues with rights claims, but they also expected federal officials to address the kinds of issues that would have fallen to local courts and that had been handled within the framework of doing what was right. So interpersonal conflicts, often involving violence and domestic issues, as well as matters involving broader questions of social justice, such as the treatment of refugees, the payment of wages, and the reunification of families. And in those cases, they expected federal venues to do what was right, not uphold their rights. Now, all the various courts under federal jurisdiction, which lacked any established body of law to handle this diverse array of claims, struggled to keep up. In reading the records, the consternation of these officials is just really palpable, and you can almost see their furrowed brows and their heads in their hands. It's like, how do I handle this case? I'm trying to come up with some legal framework in which to do this. None of these issues were really what court martials had ever handled before, needless to say. But African Americans persisted, pushing past this jurisdictional boundaries in pursuit of justice. And the exercise of federal authority in cases of this kind then might have been temporary, if not for passage of the Reconstruction Amendments, particularly the 14th Amendment, which gave the federal government authority over states' handling of rights, something that the federal government did not have before. And to be sure, these powers are limited and largely negative. The 14th Amendment placed restrictions on states prohibiting them from making or enforcing, and I'm quoting here, any law which shall abridge the privileges or immunities of the citizens of the United States, or depriving any person of life, liberty, or property without due process of law. It also prohibited the denial to any person within its jurisdiction the equal protection of the laws. But it did not extend rights to African Americans, language that is often used to describe the 14th Amendment. Actually, I've used that language before, even knowing what the 14th Amendment did, but it's so deeply ingrained, this idea that the 14th Amendment extends rights, that it is really deeply embedded in our habits of speech. But actually, the 14th Amendment could not do that because it did not establish a federal standard of rights, let alone allow the federal government to define rights. That negative power was nonetheless profound, particularly in the states of the former Confederacy. The 14th Amendment forced states to extend rights to African Americans, which made it possible for Maria Mitchell to turn B.D. Armstrong's assault into a legal matter. If she had still been enslaved, Maria Mitchell would have had difficulty making the assault into that legal matter, making it into a crime. She would have given information, like the two slaves I mentioned earlier. A local official might have prosecuted the act as an offense against the peace, but that was unlikely. Instead, a white official would have been more likely to see that as an act of justified violence, of legal discipline, legally sanctioned discipline, that masters could inflict on a recalcitrant slave. After passage of the 14th Amendment, though, Mitchell and other African Americans could file charges because of their civil rights, enabled by the 14th Amendment, enshrined in state constitutions, and protected then by the threat of federal intervention. Their rights then allowed them to act on their ideas of what was right. And what happened in those local courts then altered federal authority profoundly. Specifically, the 14th Amendment opened up paths for ordinary Americans' conceptions about what was right to migrate out of local venues through that framework of rights. Before those constitutional changes, Americans' claims about what was right, they remained local. Local jurisdictions handled each case, and once settled, it ended there. And such cases never made their way into state jurisdictions, rarely, and never a federal jurisdiction. And jurisdiction made all the difference. Maria Mitchell's case did not migrate out of her local court, but the words point to the logic of the process that did allow other similar claims to travel into new jurisdictions. B.D. Armstrong's actions were not right, and they violated Maria Mitchell's rights. When claims about what was right were attached to the framework of rights and placed in the context of state and federal jurisdictions, they acquired meanings that they did not have in local jurisdictions. They were no longer about the particular conflicts of the particular people. Instead, they involved rights universally applicable to others in like circumstances and enforced by the authority of state or federal government. The framework of rights allowed one person's claims about what was right then to acquire the power of a universal claim. They could even acquire status of constitutionally protected rights. And one of the most dramatic examples here is access to public venues and services, such as streetcars, railroads, restaurants, hotels, and even government jobs, things that we take for granted today as a civil right. But in the early 19th century, these claims to access involved maintenance of the public order, not rights. To the extent that questions of access were involving rights at all, it was this nebulous idea of social rights. There were privileges established in context and that varied from one community to another and that were regulated by local areas. So vendors of public services were required to serve the public and were subject to regulation, but such expectations of public regulation never guaranteed access. To the contrary, access to public property, sidewalks, streets, buildings, that sort of thing, had always been restricted, particularly for African Americans, but also for women, all in the name of protecting the public order. So the result is a patchwork of local ordinances and long-standing customary practices which constrained where Americans could go in public and how they could act in public. But during and after the Civil War, African Americans framed claims to new spaces in terms of rights that the state and the federal government should protect. And the Civil Rights Act of 1875 then explicitly acknowledged such claims as rights. Now, the 1875 Civil Rights Act provisions were subsequently declared unconstitutional, but ultimately cases involving access to public space continued to cast the issues of access in terms of civil rights, and that characterization ultimately stuck. And in fact, we have that characterization today. And in doing this, what was happening is people were substituting their vision of right by using rights. So my focus here has thus far been on cases involving African Americans in the states of the former Confederacy. But in ending up here, we need to think about the larger implications. And the implications of this era's constitutional changes did not actually end with African Americans, which is the common story of the 14th Amendment and the Reconstruction Acts. And actually, that amendment and the Reconstruction Acts altered the relationship of all Americans to rights and the federal government. They positioned the federal government as an arbiter between all Americans and their states, while also elevating the importance of rights as the means by which Americans could access federal power. And it did not take them long to do so, which brings us to white women and butchers. First in Bradwell v. State, and then butchers in the slaughterhouse cases. Both of these cases were heard by the Supreme Court in 1873. So Myra Bradwell, the Bradwell in Bradwell v. State, played an influential role in Illinois legal circles as editor of the Chicago Legal News, the publication on which many lawyers in the state depended to keep current with law. It was then, since she was the legal matron of the entire state of Illinois, deeply ironic when the Illinois state legislature, filled with lawyers who read her publication, refused to consider her application to the bar. Not one to be cowed, though, Bradwell challenged the decision, making creative use of the 14th Amendment. And she was also actually using arguments that other women's rights activists were advocating at the time. And she admitted that the opportunity to apply to the bar was not in itself a right. But even so, it was centrally connected to her right to pursue her livelihood and her property interests, which were connected to civil rights at this time. So when the legislature refused to consider her application, she said, they had denied rights to her that were granted as a matter of course to other male citizens. Now, the U.S. Supreme Court in 1873 rejected the first part of the argument, which was her claim that protected rights included the right to pursue a livelihood. And in so doing, they also evaded then the second part of her argument, her claim that federal protection to rights extended to women. They didn't go there at all. But still, her use of the 14th Amendment illustrates a broader transformation underway. So it is difficult to imagine stranger allies than Myra Bradwell and butchers in New Orleans in the slaughterhouse cases, but there are actually very distinct parallels. The butchers here were challenging an ordinance that regulated the slaughtering of meat and among other things required licensing and a designated central location for slaughterhouses, actually downstream of the city. You can imagine upstream slaughterhouse, not so good, right? Downstream regulation here for obvious reasons. Now, the New Orleans ordinance here is actually not unusual. State and local governments had traditionally regulated slaughterhouses where butchers worked because of the obvious health risks. But the butchers in New Orleans had, well, a particular beef, so to speak, with their government, and they were mostly white men, mostly supporters of the Democratic Party, who saw the regulation as overreach on the part of the Republican Party that was then in control of the city. And so with the backing of their Democratic Party's leadership, they reached for the laws of the Republican Party, their political opponents, and used the 14th Amendment to protect what they saw as their right, the right, like Myra Bradwell, to pursue a livelihood as others could. Now, both Bradwell and Butchers framed access to economic opportunities as a right protected by the 14th Amendment. And the court in 1873 rejected the Butchers' claims just as it did Bradwell's, upholding states' rights to regulate for the public good, which is actually not such a bad thing if you think of all the slaughterhouse stuff floating down the river. Now, in the slaughterhouse case, the court was also explicit in trying to limit the meaning of rights in the 14th Amendment, insisting that it was designed to protect the civil and political rights of African Americans only, and that was it. You can't use it for anything else. It was not intended for these more expansive uses, which the butchers and others were trying to put it to, and in both cases, the judges sought to contain the multiplication of rights. Now, these two cases were harbingers of arguments to come, arguments that connected the 14th Amendment to economic claims and ultimately a broader array of rights claims. And those 14th Amendment claims often came at the expense of protecting civil and political equality of African Americans. And yet, the cases for formerly enslaved people like Maria Mitchell, people who were claiming access to public venues, who were claiming political rights, had a lot in common with those of Myra Bradwell and the New Orleans butchers. They all made rights claims, appealing to federal authority either directly or indirectly. All of these Americans expected a lot of federal jurisdictions, and they were not alone. There are a whole bunch of cases involving an amazingly diverse array of actors in this period. Grain elevator operators, German brewers, bakers, just to name a few of kind of the hallmark constitutional cases of this period. And all with actually expansive views of federal power and what it could accomplish. Now, those views were firmly embedded in the constitutional change of the Reconstruction era that dealt with rights, but did so in a way that tied rights to expectations that legal venues could also right wrongs, that rights could make the world right. And if anything, the connection between rights and what was right grew even stronger in popular connections of the legal order, which increasingly identified rights as the means, even the primary means, to achieve justice. My students do this all the time when they talk about their rights in the context of my class. It's like, you actually don't have rights here, but this is the language they use. I have a right to an A. It's like, not so much. So this link carries its own problems, and it still does. Individual rights, even in their most expansive form, have definite limits when it comes to achieving social justice. The rights of one individual do not necessarily translate into what is good for everybody. Still, the policy changes of the Reconstruction era allowed the aspirations of a diverse group of Americans to move into the realm of federal law for the first time, and once there, to acquire the status as universal legal principles. So the specific claims express the values, then, of conflict, values of particular groups of Americans, very diverse group of Americans. But at the same time, while those claims to rights and what was right was in conflict, it is actually part of a deeply rooted, common governing practice that is widely held by a broad range of Americans from all parts of the country and all walks of life. So the commonality is there in the practice. The conflict is what we want out of that practice. And those conflicts were and are the point. These cases are examples of the efforts of Americans, all kinds of Americans, to make their view of what was right into a right. And the results then remade the relationship between Americans and the nation state, raising expectations about the federal government's role in maintaining a just public order. Before it was the post office, now, in the late 19th century, 20th century, 21st century, it is a place we look to do the right thing. Those expectations could only result in conflict, since there was and is no consensus among American people about what is right, about what constitutes a just society. At the same time, though, the conflicts are necessary. And they were necessary, and they still are necessary. They're about our aspirations for what the nation can be, and they're about our faith in the law to realize those aspirations. Rights are things, the means through which we actually have this conversation about the public order now. And that process is going to be about conflict. There is no mythic point in the past where we all agreed. And rights claims are always going to be controversial and contentious because they are also about differing conceptions of what is right. They are at the heart of also our political debate about what constitutes a just society. Thank you.